We're on the air. This is Radio Entrepreneurs, and all week long we're being hosted by our friends over at O'Brien and Levine Court Reporting Services. That means we're on the record. We're speaking to attorneys all week long. My name is Jeffrey Davis of Mage. I'm here with Mark Z from Mark Z Legal Staffing. Mark is in his element right now.
It's great to be your sidekick, but we're in the Super Legal Series.
The Super Legal Series. And our next guest, I hope I get all these names, but your name will be easy. Stephen Weatherhead. Why don't you tell us first about the firm?
Sure, thank you. We are an employment and benefits law boutique. We formed here in Massachusetts about a year ago. We're all, like to say, refugees of some of the larger firms in the city. And we really do two different areas, the employee benefits side, which is ERISA, Affordable Care Act, which is keeping at least two people busy full-time, executive compensation and things of that nature. And then the employment side of the house, which is the traditional management side, employment practice, compliance, training, litigation, et cetera, and all things employment law. But today we're going to focus more on the non-competition aspect.
And so before we go into that, I wanted to ask you, you're a little bit different, though, than some people who specialize in the area, because you've been on the other side. I mean, when I say that, you've been on the in-house side. You were with a major company as a general counsel, correct?
That's true. I was in private practice for about 10 years. Then I spent a couple of years serving as the global employment counsel for a large international consulting company. Spent a lot of time on an airplane, a lot of time in foreign countries. I was single at the time. That worked. And after a while, that
No, it grows old fast.
It really does. People who say that business travel is fun don't travel for business. And then I did become a general counsel of a small software company, Salary.com. Which then went public, and then I decided to go back into private practice in the boutique model,
Right.
Which is where I am now.
So we're going to talk about non-competes, and that's always an ongoing area of concern for most employers I know.
It is, and it's a really dynamic area because the law doesn't necessarily change, but the enforcement of it or the approach to it, I always say, it's a pendulum, and it sort of flows with what the economy is doing, what the makeup of the judiciary is, frankly. Some judges are very loath to enforce these. Others say a contract's a contract, and that's what the parties bargain for. I would say right now in Massachusetts, we're particularly since the Great Recession started in 2008, we're supposedly recovered a little bit. Judges are obviously more reluctant to enforce these strictly and put someone out of work under these conditions, particularly when people have been let go involuntarily. Legally, it makes no difference whether the employee was terminated or resigned in terms of enforceability. Although that's a factor a judge will certainly weigh in a court of equity if necessary.
Well, they look at, as you say, talk about enforcement. On one hand, I know courts really don't want to enforce a lot of non-competes, particularly in Massachusetts. But on the other hand, from a small business perspective, if you train somebody and you've invested in somebody, and then all of a sudden that person, for one reason or another, doesn't cut it because maybe they just didn't want it to work at your firm, and then now all of a sudden they're going over to a big firm and they bring all the experience they've gained that you've trained them to this firm. It's not. I was going to say that's not legally fair, which is why you had them sign an agreement, because you were investing in them.
Exactly. That's part of the argument, although frankly that holds less sway with judges sometimes because the argument that you need to invest in all employees to some degree with
Right.
respect to your particular operation. But they're really designed to protect confidential information,
Right.
With the idea that even someone with the best of intentions and every intent to honor the agreement sometimes could just inevitably
Make mistakes.
Right, you make
Right.
mistakes. It's so embedded in your makeup that you
Database
use it or
usage.
disclose it exactly.
Right.
Obviously there's the extreme cases where someone just simply steals client lists. That's a
Right.
different case.
Right.
Also to protect goodwill. Most salespeople I've ever talked to say that's my client. Well, guess what? It's actually the company's client, and it's
Correct.
their goodwill and it's their relationship.
Right.
So it's to protect that as well. Because and salespeople have a lot of product knowledge and product roadmaps and things of that nature. So it's really designed to protect those things.
Right.
But they can't obviously restrain ordinary or fair competition. But that's the big question. What does that really mean?